Presentation, I would like to invite you to join me in approaching animal rights from the perspective of family law. Family law and animal rights, you may ask, what does one have to do with the other? Well, maybe some of you have a pet, and this pet is like a family member for you. Or you may think of divorce proceedings, where courts regularly have to decide on the right to spend time with the dog formerly belonging to both spouses. Before a German court, for example, a divorcing couple reached the following settlement. The dog is brought to the applicant on Friday's afternoon and brought back by the letter to the respondent on Monday morning at the latest. During the week, the dog lives with the respondent. The parties agree that the expenses of keeping the dog are borne equally by the parties, except for the feeding. And there are even movies about such post-marital squabbles. Leaving these rather petty details aside, I would like to look at the bigger picture and apply the structure of family law to animals in order to contrast the prevailing paradigm of dealing with animals under the flag of property law. To illustrate this approach, I would like to conduct an experiment, not involving any animal testing, but rather the testing of legal mechanisms, an experiment of thought. In our experiment, we apply family law to animals as if they were children. First, we will detect which results this experiment yields. Second, I will discuss the results by comparing them with the property law perspective. Third and last, I will draw some conclusions from our experiment. So applying family law to animals concerns different aspects of the family relationship. Let's start with the establishment of the family relationship. How is a family relationship, a relationship between parents and a child, established? Traditionally, we apply biological criteria to determine legal parentage, maybe with certain presumptions to facilitate the assessment. Obviously, such biological criteria are not fertile to establish the relationship to an animal. However, many jurisdictions give more and more weight to other factors based on social criteria. A social relationship can already be established by mere exposure, as psychologists put it. Thus, a social relationship can emerge from spending time together. It can intensify over time through common habits and strong affection. Those are factors that can easily be applied to animals, specifically to companion animals. As regards farm animals, we will have problems to find any pro-social human behavior. But in family law, there is still another criterion on which legal parentage can be based, namely the intentions of the parents. This criterion shows up in cases of surrogate motherhood, in the legal options to acknowledge fatherhood, and, of course, in the procedure of adopting a child. Thereby, parentage can be derived from former parents or be established for the first time if a child has not been assigned to any parent so far. For an adoption, the previous parents and the adoptive parents usually have to consent, while the child is rarely involved in the transaction. Furthermore, most jurisdictions require approval by a court and certain qualifications for the child and the adoptive parents. Often, the adoption is only approved after a probationary period. Such derivation from a previous relationship lies at the basis of any industrial or commercial relationship to animals. And if the relationship extends to the progeny of an animal, biological criteria, after all, do come into play. Finally, wild animals can generally be regarded as independent from any special relationship to humans, just as most human adults are from the viewpoint of family law. As a second aspect of the family relationship, we can ask who is in the position to represent the vulnerable relative in legal dealings. Sometimes it is argued that animals cannot have rights because they could not assert their rights, lacking the ability to make a rational decision and to communicate such a decision. This, however, would be true for many children, especially of young age, and even for some adults with cognitive impairments. Yet family law provides for mechanisms by which decisions are made for such vulnerable relatives in their respective interest. With regard to assets, we can generally distinguish three functions: the benefit of an asset, the burden of liability with that asset, and the management of the asset. In many areas of law, the management is separated from the other functions and assigned to a different actor, while benefits and liability are independent from the ability to manage and to communicate management decisions. Family law usually assigns the management to relatives who form a stable community together with the child, that is, both parents, if they are married, live together, or have agreed on joint custody. Depending on the subject matter of a decision, they have to decide jointly, or each of them can decide alone. For certain far-reaching decisions, the permission of a court or a state agency has to be obtained. In case there are no such close relatives, or such relatives are not suited for representing the child, or in our case the animal, the role of a decision maker has to be filled by a third party. To this end, courts can appoint a guardian, which may be a private individual, a professional, or an organization. Especially for organizations, there may even exist an obligation to serve as a guardian, and as a last resort, a state agency can step in as a guardian. Adults that are not fully able to look after their interests may also require such a mechanism, but limited to certain matters or circumstances. In the parallel we have already drawn, this limited human intervention might be adequate for wild animals in a situation where they are in need of special protection. Having now seen who decides, we can have a look at the substance of a decision. Which duties guide the decision-making for the vulnerable? I suppose most of you will be aware that the guiding principle for decisions affecting children is the welfare of the child, also styled the child's best interests. This is, of course, a very broad and vague concept that needs to be filled with more concrete rules. For some situations, the law provides somewhat more instructive guidelines, but in general, the welfare of a child is a standard defined by social, ethical, and cultural norms, which are referenced by the law. In a second step, these external norms can be adopted by the law and can find their way into legal norms. Against this extra-legal background, it is not surprising that the protection afforded to children by the law varies greatly at different times and in different cultures. In this vein, social progress in the field of children's rights is reflected in international conventions, particularly the UN Convention on the Rights of the Child, which dates from 1989. We can also find traces of the development in legal terminology. Whereas in the 1980s, the decision-making by the parents was styled parental powers or parental authority, we now speak of parental responsibility. Translated to our field of study, the concept of animal welfare springs to mind, a concept that also references social norms when it prohibits unnecessary, undue, unreasonable, or unjustified suffering as the standard is circumscribed throughout many national laws. Another important development in family law is the continuous abolition of discriminations. In the context of legal parentage, illegitimate children have long been, and in some jurisdictions still are, treated less favorably than children born in wedlock. This discrimination may bring to mind the deeply rooted distinction, or discrimination, if you will, between companion animals and working animals. Also, the material interests affecting child welfare resemble the interests relevant to animal welfare. The freedom from physical harm and the freedom of movement, which can both be restricted by decisions of the parents in a particular case. The parents decide on the residence and the contacts of the child and are responsible for educational decisions, which may include sanctioning a child and has historically included severe and violent sanctions. Of course, child welfare also has a financial side. Money to be used for the child's benefit is paid by means of maintenance. This money is then usually also managed by the decision-making relative. As a last aspect of the family relation, I would like to briefly go into the issue of enforcement. How are the legal duties towards relatives enforced? Here we have to be aware that the family is an autonomous social system with its own self-made rules and its own enforcement mechanisms. As with every such self-regulatory sphere, external control suffers from certain deficiencies. It is difficult for a court or a state agency to gain information about what's going on in a family, and it is intricate to interfere with family practices and to substitute them with rules imposed by the state. Therefore, the state usually confines its intervention to cases where the self-regulatory powers of the social system are manifestly failing. In case of such failure, the means of state intervention are manifold. The decision-making powers of a relative can be curtailed or removed entirely. A relative can be deprived of the benefits from the family relation, such as the contact with the vulnerable relative. Further liability for damages may ensue towards the aggrieved relative, and criminal liability towards the state will be available in severe cases. But all these options are faced with the core problem of deficient insight, the high efforts required, and the overburdening caseload, all problems we are just too familiar with as regards animal welfare. So this concludes our experimental sojourn into family law. I will now turn to the second stage, discussing our results in comparison to the prevailing paradigm of property law. At the outset, it may be instructive to note that the origins of Western family law actually have distinct similarities with property law. Roman law as well as Germanic law treated children in the very same way as property, owned by the paterfamilias, or the father as head of family. So let's have a look at the relations implied by ownership as compared to parentage. The role of the parent is now called owner, O. The role of the child could be replaced by thing. For our purposes, I call it A for animal, as this is their current status. How is ownership established? In the first place, you become the owner of a thing if the former owner transfers her title to you. Now, the intention of the parties is a criterion that we also encountered in the family law context. It was maybe not the main criterion, but it was present. And if we trace the chain of owners back to its origin, ownership has to be acquired by other means, like appropriation or manufacturing from existent property. Although these transfer of title and social criteria now, although these means like appropriation or manufacturing may seem natural to us, they have an inherently social or economical dimension if you think of the different access to resources or of the question who is considered to be the manufacturer. Besides the intention of the parties and social criteria, the owner of animal progeny is determined by biological criteria. Most legal systems allocate ownership to the owner of the mother. Who makes decisions with regard to the property owned? In principle, the owner decides how to deal with her property. There can also be two or more owners whose decisions are organized in the forms of co-ownership. Oftentimes, minor issues can be decided by one owner alone, while more important issues have to be decided jointly. And for some decisions on the use of your property, you need the permission by a state agency. The decision-making powers can further be separated from someone's own interests in the property, which common law jurisdictions traditionally accomplish by means of a trust, with the trustee only as the manager of the property, but not as the beneficiary. Trustees occasionally have a function corresponding to that of guardians, and can likewise be appointed by court order. As you might be aware, in many states of the US, it is expressly regulated that a trust may be created for an animal without any human beneficiary. Which duties guide the decisions on the use of the property? Though the owner is principally free to deal with her property as she likes, this power is always subject to restrictions in the interest of third parties or of the general public. There is no such thing as free ownership of property in an absolute sense. With this in mind, animal welfare law could restrict the use of owned animals just as much as child welfare restricts parental powers. Of course, this raises constitutional issues or questions. The fundamental right to property may be infringed, but ultimately this boils down to a weighting of the interests incorporating societal views. How are duties of the owner enforced? The owner can be removed, property can be confiscated, and liability for undue conduct may be imposed. Whether this is formally done in the name of the thing owned or in the name of the state is of no material relevance. All in all, it turns out that technically we can achieve the same results through family law and property law. In family law, the child has rights that are subject to parental powers. In property law, the thing owned does not have rights, but the owner's powers are subject to the protection of the thing. In both cases, enforcement lies to a large extent with the state. Therefore, we can view family law and property law as two different packages with potentially the same content. Similarly, ascribing rights to elements of our surroundings is nothing more than putting a label on them for the purpose of operationalizing legal analysis independent of its particular results. Third and last, what follows from these findings? I would like to draw 4 conclusions. First, family law can serve as a framework for constructing rights held by animals. So the mechanisms of family law provide one possible specification of the rather vague political demand for animal rights and may serve as a model if animal rights at some point may be implemented. Second, a subject of rights need not be a subject of duties. This conclusion responds to the seemingly logical argument sometimes brought up against the possibility of animal rights, namely that animals cannot be made subject to duties and rights are not conceivable without duties. Giving rights to children who, at least at younger ages, are not bound by legal duties invalidates this argument. Third, animal welfare and animal rights are merely different constructions that can be filled with the same level of protections. As we have seen, the same relationships fit into different regulatory patterns. In fact, one could even argue that animals already do have rights and that they are just curtailed to a large extent due to opposing interests. Fourth, framing the protection as animal welfare or animal rights does have an impact on the attitude of decision makers. While I have negated the substantial legal difference between animal welfare and animal rights, that does not mean that there is no difference at all. The famous psychologists Daniel Kahneman and Amos Tversky have found that framing effects are omnipresent in our decision making. This means that decisions are influenced by how different options are presented, how they are phrased, for instance. Especially the framing of a problem can define a default option, which is initially favored by a decision maker. In this context, animal rights might shift the relation of rule and exception, towards harming animals as the exception which has to be justified in a particular case. Or put in the frame of a well-known metaphor, right holding might afford animals a seat and not just a plate at the table of brotherhood. Thank you.